Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
Now, in finance feeds here, we had some commentary from John Deaton regarding the ruling here that is coming up from Judge Netburn about the motion for reconsideration. He said, if Judge Netburn ultimately rules that the emails must be turned over, it's huge. Why? We've talked about these in great detail and how the SEC previously had said that this was the personal opinion of Bill Hinman, but now it's calling it public guidance. There's this constant back and forth regarding XRP or Ether. If these documents do get turned over and we do finally have them see the light of day, then it will truly be a huge outcome. Deaton continued saying, don't forget, even if the SEC persuades her that the emails are covered under the DPP, she can still pierce the privilege and order the documents produced. If she rules the emails privileged but orders the SEC to produce them, it means XRP is referred to and or the evidence is indeed exculpatory. If the judge believes evidence is exculpatory and Ripple has no other means of obtaining the evidence, she will pierce the privilege. If she overturns her previous ruling and decides the emails are privileged but doesn't pierce the privilege, the emails, although helpful to Ripple, are likely not as big as we perceive. So this will be a big decision. We're still waiting on a little bit more of the back and forth. Expect to hear the Ripple response by the 25th, I believe, is the due date, which is the end of the week. So make sure you are subscribed so I can keep you up to date when we get the details on their rebuttal to what the SEC has said. And now finally, in the big story that I think you are going to be the most interested in, the SEC has filed a request to file a Sir reply regarding the motion to strike, citing the SEC versus Library decision, in which the New Hampshire federal judge granted judgment on the pleadings on an unrelated selective enforcement defense. So here is the document. Again, this courtesy of James K. Filan. You can see the tweet here, and here's the document. Both will be linked below. You can see what they have filed, and then you'll see the actual document here below. So let's just take a quick look through this because it's not a overly long one, and I think it is worth considering here. So addressed to Judge Torres from the SEC, plaintiff SEC respectfully requests the court's permission to file the attached 3-page Sir reply to defendant Ripple Labs' Sir reply in opposition to the SEC's motion to strike Ripple's fourth affirmative defense, that's the fair notice defense. Courts have discretion to infrequently consider Sir replies when there is a good cause to do so. They give some case law here and say here the court should exercise its discretion to consider the SEC's proposed Sir reply so that the SEC can, 1, present to the court highly relevant recent authority that directly refutes the arguments Ripple makes in its Sir reply, and 2, respond to arguments Ripple makes for the first time in its Sir reply. Specifically, Ripple's Sir reply argues the court cannot consider the SEC's public enforcement actions in the digital asset space filed before this lawsuit. On February 7, 2022, a New Hampshire district court granted the SEC's motion for judgment on the pleadings and struck an affirmative defense similar to Ripple's in a case solely alleging unregistered offers and sales of digital assets in the SEC versus Library case. While styled as a selective enforcement defense, the Library affirmative defense alleged the SEC treated Library differently from other similar blockchain companies with no rational basis for the difference in treatment. In striking the defense, the court observed the SEC has brought at least 42 failure to register claims against other digital currency creators, with at least 19 of those actions asserting registration violations without accompanying allegations of fraud. The court concluded that Library had not presented a valid reason to disregard those other enforcement actions and held Library's admission that the SEC has been pursuing enforcement actions against multiple other digital currency creators dooms its selective enforcement defense. Library thus refutes Ripple's Sir reply contention that the court cannot consider the SEC's prior digital asset cases. LBRY likewise dispels Ripple's argument that the SEC's history of digital asset enforcement actions does not justify striking Ripple's fair notice defense at the pleading stage. Beyond providing support for the SEC's request to take judicial notice of its prior enforcement cases, LBRY refutes Ripple's surreply argument that its fair notice defense should not be stricken because this case does not involve fraud allegations or an ICO. LBRY rejected a similar defense at the pleading stage, even though that case, like Ripple's, did not involve an ICO and only contained allegations of unregistered offers and sales. The SEC's proposed surreply elaborates on the above discussion of LBRY and contains additional authority that responds to arguments Ripple raises for the first time in its surreply. Accordingly, good cause to grant this motion and allow SEC's proposed surreply, which is attached here to as Exhibit 1. Respectfully submitted, Benjamin Hennerauer, who I don't believe we've really heard from much in this case. Now, a thing I want to call back on here is when we first talked about the LBRY case 8 months ago or so, this is what I kind of predicted, is that the SEC would try and drag this on so that they could use LBRY, who has the weaker ability to defend versus Ripple, and then get some sort of precedent there that they could use here or elsewhere. LBRY doesn't have the same financial or legal backing that Ripple does, and so they can't put up the same kind of fight in this case. They just don't have the funding. You even saw they were trying to get some fundraising and get people to chip in to help with their legal defense. This is now the problem we see. Because of that, because the SEC has delayed this case numerous times, they're now starting to get action in other cases that they're trying to bring back in here and cite as precedent and case law that they can use against Ripple. This is a problem because the longer this goes on, the more instances they're going to bring up and be able to find. So again, what are they trying to bring here? Well, there's a few things. One, even Jeremy Hogan talked about the different stages and how this was a different stage in the case versus some of the other citations. Well, now they have an example in the LBRY case of a defense at the pleading stage that was stricken by the court. The court granted the SEC's motion. And then you also have here another example that they're talking about with the fraud allegations and citing instances here based on this case law that the fraud allegations aren't relevant. So if this is allowed, it does help bolster the SEC's arguments against the fair notice defense. But let's take a quick read through this one as well, because it's short and it's worth seeing in here. Now, some of this might be redundant to what we just read, but it's important to see their surreply in its full context. So here's what they say in their surreply, excuse me. So the surreply from SEC. In Ripple's surreply, Ripple argues that the court should neither take judicial notice of nor consider the more than 70 publicly filed SEC enforcement actions related to digital assets cited in the Cornerstone Research report attached to the SEC's reply brief. Ripple claims that those enforcement actions cannot establish at the pleading stage that Ripple had sufficient fair notice that the SEC would consider Ripple's XRP distributions to constitute the offer or sale of securities. So remember, Ripple's surreply, they basically argued against both of those sets of documents that were cited from the Cornerstone Research report, or not documents, but cases, half of which were ICO, half of which were another instance. But either way, neither of those sets of cases were relevant or directly correlated with what is happening with Ripple. Ripple is a truly unique one, is what their surreply stated. But now, here the SEC continues, new case law further supports the SEC's position. On February 7th, 2022, note this was just a couple weeks ago, a New Hampshire district court granted the SEC's motion for judgment on the pleadings and struck an affirmative defense similar to Ripple's in a case alleging unregistered offers and sales of digital assets, but not fraud. in the SEC versus Library case. While styled as a selective enforcement defense, the Library affirmative defense alleged the SEC treated Library differently from other similar blockchain companies with no rational basis for the difference in treatment. In denying the defense, the court observed the SEC has brought at least 42 failure to register claims against other digital currency creators, with at least 19 of those actions asserting registration violations without accompanying allegations of fraud. The court concluded that Library had not presented a valid reason to disregard those other SEC actions and held Library's admission that the SEC has been pursuing enforcement actions against multiple other digital currency creators dooms its selective enforcement defense. As in Library, Ripple does not and cannot dispute that the SEC filed or publicly filed the digital asset enforcement actions cited in the Cornerstone Research report. Nor does Ripple claim that Cornerstone Research misstates the statutory violations charged in those lawsuits. Thus, Library provides additional authority for this court to consider the enforcement actions cited in the Cornerstone report and to rely on those actions to strike Ripple's affirmative defense at the pleading stage. They give another case citation here, stating, "A court may take judicial notice of undisputed matters of public record, which may include court records available through PACER." The SEC's history of enforcement actions in the digital asset space is similarly fatal to Ripple's affirmative defense. Nevertheless, while imploring the court not to consider those actions, Ripple argues they were insufficient to provide Ripple fair notice that its unregistered offers and sales of XRP could be illegal. Namely, Ripple argues that many of those SEC actions involved allegations regarding ICOs as opposed to Ripple's offers and sales of, in its words, an established digital asset. This argument is based on an incorrect characterization of the fair notice defense. Ripple's argument boils down to this: because none of the SEC's prior digital asset cases involve facts identical to those in this case, Ripple lacked sufficient fair notice, such that it cannot be liable for violating Section 5's strict liability provisions. That's worth noting here. Even in their own document, the SEC is acknowledging what Ripple said and what we just talked about a second ago. The facts were not the same in the Ripple case versus the other cases filed. And that's the thing. That's what Ripple's saying, is you've never done this before. We didn't have notice. We didn't know. And now the SEC does at least acknowledge that, but now they're trying to twist it here. But fair notice does not require such exact factual correspondence, and Ripple cites no case that suggests anything to the contrary. Rather, the abundance of case law interpreting and applying Howey at all levels of the judiciary, as well as related guidance issued by the SEC as to the scope of its regulatory authority and enforcement power, provide all the notice that is constitutionally required per this case cited U.S. versus Zaslowski. Moreover, Ripple's contention that the SEC's earlier actions alleging illegal sales of digital assets were limited to the ICO context is factually inaccurate. For instance, in SEC versus Telegram, the SEC alleged unregistered offers and sales but not fraud in a private offering of digital assets only to 175 entities and high net worth individuals. Similarly, SEC versus Kick involved both an ICO and a private sale of digital assets, but none of Judge Hellerstein's application of Howey depended or changed based on which part of the unregistered offering was at issue. Here, Howey and its progeny's flexible rather than static principle would be nullified by ruling that a fair notice defense can beat any claim involving offers and sales of an investment product that are not identical to those previously deemed to involve a security. The court should reject the invitation to issue such a ruling. And you can see submitted Benjamin Hanauer again, and then Mark Sylvester and the whole crew at the SEC. So there you have it. This is important. This is, again, the SEC had two sets here. The first thing they had was the request to file the SIR reply, and then the SIR reply, or SIR reply, and then the SIR reply itself. So the SEC is trying to bring in the Library case, again, arguing the fact that the stage at which this was determined, the pleading stage, is the same as Ripple, and so they're bringing it in to say, hey, it's okay, you can do this, here's a case citation, and then they're talking about the fraud allegations and the ICOs as well. So I think we were going to hear some very interesting commentary on this in the next little bit. We will probably see Ripple file some kind of document to say how they oppose the Sir reply, and then Judge Torres ultimately will have to make a decision. Remember, she did allow the Sir reply, so now the question will be, does the Sir reply get to come in?
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.